This morning's docket, case number 109123, State v. Hankins.
May it please the court, defendant appellant Anthony Hankins appears by and through counsel Kate Sigtman. I would request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. In the Court of Appeals decision, they did raise a procedural bar. I filed a 609 letter. I believe that Dickey disposes of that procedural bar as this is a score issue as opposed to the existence of the actual offense issue. So unless the court has questions or concerns on that, I'd move on to the merits. Alrighty then.
How do you address the argument that what the stipulation was is to the existence of the conviction?
Well, we're not disputing the fact that he was charged and prosecuted with an offense in Oklahoma. But I think whether or not something is actually considered a conviction for a criminal history score purpose is going to be defined by Kansas law, which goes to criminal history score, which, as Dickey found, we can challenge how you score it. It's not like another typical challenge to the existence of a conviction where someone is claiming it's not them, or it's a mistaken identity issue where you have to pull fingerprints or other court records to prove something actually occurred. We're not disputing it occurred, we're disputing how it's scored. So I think under that grounds it becomes a statutory interpretation issue this court can consider. The Court of Appeals and the briefs submitted in the Court of Appeals tried to make the analogy that the deferred judgment program through Oklahoma was a diversion and therefore it should not be scored. I think since this court has re-examined the Kansas sentencing guidelines on a couple different occasions since then, that the better place to start is whether or not this meets the definition of a conviction as defined by Kansas law. Obviously, Kansas law is going to control what Kansas considers in scoring a criminal history. Conviction is defined by the Kansas Criminal Code. It does not hold a separate definition within the Sentencing Guidelines Act. And that conviction in the Kansas Criminal Code says that unless circumstances deem otherwise, a conviction is a judgment of guilt upon a plea of guilty. I think the phrase there that operates to define conviction is going to be the judgment of guilt phrase. Obviously, a no contest plea, which results in a judgment of guilt and imposition of sentence, is going to be counted as a conviction, as is a jury verdict that results in a judgment of guilt. So I don't think a plea of guilty is going to be dispositive of what defines a conviction. More so, a judgment of guilt is going to be dispositive of that. So in looking at that, Kansas criminal history scores convictions and expungements.
Could I ask a factual question? This
Yes.
was a deferred judgment in Oklahoma.
Correct.
And that's, was it completed
It was
at the time that the Kansas sentencing took place?
Correct. It was completed. The conviction had been, or the case had been dismissed.
Okay, my understanding of Oklahoma law is that once you've met the requirements, then the plea of guilty is expunged from the record.
My recollection of this, and I looked at it, is that you don't actually enter a judgment of guilt, and they do expunge your plea that's tendered and close the case without any finding or judgment of guilt against you. So yes, the plea is offered to the court. The court holds off on accepting it and imposing sentence so that you can complete your probationary requirements. And I say probationary requirements for lack of a better term.
Just to clarify, at the time of sentencing in Kansas, the plea of guilty had been expunged from the Oklahoma record.
That is correct. And the definition of expungement is different, or in Kansas at least, is not that a plea is actually withdrawn or taken out of the record and the case is dismissed or is no more. An expungement is defined by Kansas law as just that you seal the records, so that only certain limited exceptions have access to inspecting those records. It does not dissolve the conviction, it does not dismiss the case, whereas a deferred judgment in Oklahoma actually results in dismissal of the case. So under that analysis, I think that supports a finding that judgment of guilt becomes more operative, because in a diversion case, the case is dismissed. There's never a finding of guilt, and diversions aren't counted. There's never a judgment of guilt, a judgment of guilt and a diversion. And so that's why it would make sense under the entire scheme that if we focus on the judgment of guilt phrase, it makes not counting diversions fall into play with the rest of the criminal history scoring procedure.
And diversion, if this had been a diversion in Kansas, if it were successfully completed, you could not count that as a conviction for criminal history purposes, right?
That is correct.
And if he were in Oklahoma and the deferred judgment proceeding had been successfully completed, Oklahoma could not use it as a conviction.
I believe so.
Okay, so the only way this gets used as a conviction is if he comes to Kansas and has an Oklahoma deferred judgment.
Correct. Or any other state that chooses to define conviction with specificity, as Kansas has done in its criminal code. So I think that under the plain language of the statute, the Court of Appeals kind of got lost in trying to compare dispositions across state lines and kind of following the rabbit hole of what was Murdoch and is no more, when we're not really comparing dispositions across state lines. There's a specific statutory provision that gives us a definition that we have to follow under the legislative definitions. As far as the rest of the case law that the Court of Appeals relied on, I think both Hogden and Macias, those are distinguishable because those out-of-state proceedings did actually have a judgment of guilt, whereas this one never resulted in a judgment of guilt. So with that, I think that lays out the points of my argument, unless the court has any other questions.
Your client received a 68-month sentence,
Correct.
and if we agree with you, he's then reverts to a criminal history I instead of H, or I believe
Correct.
that's correct. And then the sentence for that is, as I understand it, would be 61 on the mitigating edge end and 71 on the aggravated end, with 68 months falling right in the middle of that. Doesn't that fit the presumptive sentence that he would already receive anyway?
Well, I think
Is there really any difference here?
I think my client would assert that 7 months in prison is a substantial difference, and that 7 months would come off of his post-release time, which also infringes on his liberty. So while it might be within the top and low end of the box, my client has a right to be properly sentenced under his criminal history score as defined by law. Now the court, if we vacate and go back, the court could say, okay, I'm going to give you 68 months or the top
71 months, right?
Correct. I mean, that is within the court's purview upon remand, but as it stands right now, I believe it's an illegal sentence.
Any more questions? No further presentation?
No, Judge. Thank you.
Thank you, counsel.
Morning. May it please the court, the state appears by Stephen Obermeyer. With regard to issue 2, I'll start on that issue. A conviction, as the court knows, includes a judgment of guilt entered upon a plea of guilty. And at the end of the State versus Macias case, the court says what matters is whether the foreign state concluded the defendant did the crimes, not whether he or she ultimately had to do the time. No matter what lenience another state may wish to show, once we are satisfied that a defendant's factual guilt was established in a foreign state, that prior crime will count in Kansas. And the analysis of all the cases that discuss another state's prior, whether it's a conviction or not, looks at what happened in the other state. And this court has the benefit of...
How is the system different in Oklahoma as a practical matter? Oklahoma deferred judgment, you have to enter a plea of guilty, but of course that plea then is expunged when the case is dismissed. In Kansas, you don't enter a plea for a diversion, but you have to stipulate to the facts that are going to be presented to the judge if you violate. So basically you have to admit to the acts that the state's relying upon for your guilt, correct?
I think the diversion in DUI cases, you have to have the stipulated facts. I'm not sure in other cases if that's required.
Well, I've never seen a diversion agreement that didn't have it in there. Maybe it's not required, I don't know.
And I would check, Justice Johnson, because we used to do that. We'd have these diversion revocations, and then we're back to prosecuting the case. And then we said, okay, well, you're going to stipulate the facts if you're going to do this. But it's at that time, when the diversion's revoked, that you have the judicial finding of guilt, or not guilt, I guess, by looking at the stipulated facts. Where in this case...
But the practical effect is, in both processes, if there's successful completion, then in the respective states, they are not convictions for criminal history purposes.
A DUI diversion...
Excluding DUIs,
Okay.
because this isn't a DUI, is it?
It's not.
Okay, so this case specific, this case, a diversion in this case for this crime and a diversion in Oklahoma would have the same effect in the respective states of not being a conviction for criminal history purposes after successful completion of the program.
In this case, a non-DUI, yes. I don't know about Oklahoma law well enough to tell the court what would happen.
Well, that leads to my question, counsel, that comes to my mind, which is, and you may not know, but under Oklahoma law, is there anything that Oklahoma courts have said about whether or not this deferred sentencing procedure establishes guilt, or whether or not there's a finding of guilt that occurs at any point in the process?
I don't know. I know a person's entitled to plea or appeal that a deferred sentence if they want to. But other than just looking at the statute, let's look at what actually happened in the case. And the court has the plea of guilty and summary of facts in the record on appeal starting at volume 1, page 91. And it goes through the litany of rights that the defendant is waiving, that he has a lawyer, he was presumed innocent, may remain silent, can call witnesses. He understands these rights. He understands by entering a plea of guilty, you give up these rights. And he answers yes. Do you understand that a conviction on a plea of guilty could increase the punishment for any future crime committed after this plea? Yes. There's a factual basis set forth as far as he had a rifle on the John Marshall football field. It concludes with, I've read this form, understand everything, my attorney's gone over it with me. On page 96, the court finds as follows: the defendant's pleas of guilty is knowingly and voluntarily entered and accepted by the court. A factual basis exists for the pleas and former convictions. The defendant is guilty as charged. That sounds a lot to me like a conviction. It's a plea of guilty entered upon a judgment of conviction entered upon a plea of guilty.
But at the time of sentencing in Kansas, that had been expunged. He had successfully completed his deferred judgment proceeding. The case was dismissed, and the plea and what happened at the initial hearing was expunged.
I think
that's my understanding of Oklahoma law.
And that's probably true. It was dismissed in 2008 in Oklahoma, and this case is a later case, so probably so. But I would hearken the court to State versus Hodgson, where the defendant was in Alaska, kind of a similar procedure. He had a conviction that had been set aside in Alaska, and the court and the argument in Hodgson was this is like a diversion because the case is dismissed. And the Hodgson court said, no, this is similar to an expungement in Kansas. And if you look at the criminal history scoring, expungements are scored. And so if another state decides to be more lenient in the way that it treats the defendants, as far as you can have this expunged so you can get a job and say you've never been convicted, that's different than looking at whether or not you've been convicted when you go through this plea of guilty and summary of facts. And then on the same date, there's a sentencing after previous plea of guilty journal entry. where the sentencing is deferred until June of 2002. He has to pay a probation fee. That sounds a lot to me like a conviction. You just can't bring some person charged with a crime and say, okay, you need to start paying a probation fee, and you need to pay a pre-sentence investigation fee.
You
need
do
to
that on a diversion, you have to pay a diversion fee.
Yes, you'd have to pay restitution and the court costs.
And a
Also,
diversion fee.
but-
And that
but-
diversion fee goes to the prosecutor's office, or it used to.
I think
Yeah.
some of it does. We end up, I think we send it to the county commission, but victim compensation, pre-sentence investigation report, and the other thing is, unlike diversion, the court decides whether you get a deferred sentence or not. In Kansas, the court doesn't decide whether you'd be an appropriate diversion candidate, and in fact, not every crime in Kansas qualifies for diversion. We can't go diverting first-degree murderers, but there's a list of crimes that can't be diverted. It's not the district court judge's call that, oh, I think you're appropriate for diversion, versus it is the district court's call as to a deferred imposition of sentence in the state of Oklahoma. So I just think this case is very similar to the Macias case, where the court looked at the procedural facts and that there was a finding of guilty, even though there was a deferred adjudication of guilt in that case.
Was Macias a Missouri that they're deferred?
Seisner was a Missouri suspended imposition. Pollard was a Missouri suspended imposition. Macias was a Texas.
Is there a distinction between those procedures and what happens in Oklahoma, or do you know? In terms of the deferred process, that whole deferred sentence and prosecution.
I'm not sure, Justice Rosen, except that in all those cases, the analysis is whether or not there was a judicial finding of guilt,
right,
by whatever you call that process in Florida or
right,
in Texas or Missouri. And there was a Florida case where there was a juvenile adjudication that did not count in Florida, but it counted in Kansas, and that's State versus Prussia. So we have several cases going back to 1977 in State versus Holmes, where a person was found guilty at trial in Kansas. He goes out and possesses a firearm, had not been sentenced in Shawnee County District Court yet after the verdict, and the court said that was a conviction. And in the other cases cited in the briefs, the court looks at whether there was a judicial finding of guilt. There's not a judicial finding of guilt in a diversion case, and that's why diversion is different, as the Macias court said, and as the Hogben court said as well. So this is not a clean slate because of prior precedent, and I think we should follow the well-settled law of stare decisis, and following that, and there's really not a reason to change the law and redefine what a conviction is or what should count in somebody's criminal history. With regard to the first issue, I know that I think it was Dickey that recently said a stipulation or lack of an objection still permits the court to consider a motion to correct sentence. And the motion to correct sentence says that a court may correct sentence at some later time. I think when a defendant appears before the court, as in this case, and says, Judge, we've cooperated, we've pled guilty as charged, and by the way, he pled to 4 different counts, so if it gets remanded, he's looking at possibly something more than a 68-month sentence if they get consent. But, so give us a dispositional departure to probation, Judge. We're not challenging this Oklahoma issue. So they proceed on that basis. And this is kind of interesting. The sitting district court judge was not there that day. It was a pro tem judge. So maybe that's the defendant's chance to say, hey, I'm not going to contest this, and I'll take my chances with the pro tem judge, because the defendant later referred to the sitting district court judge as a hanging judge. So why not proceed with sentencing on the day that you're there early on. So how can you invite that error and say we don't want to proceed? We want to proceed today with the pro tem judge, and then say, okay, you can come back later and we'll correct your sentence if you don't get what you want. I think.
How do you square that with our cases? I think when the sentencing guidelines first came in, we had some plea agreements where the defendant agreed to have increased sentence outside the grid, and we said no. The Supreme Court said no, you can't agree to an illegal sentence. If it didn't fit, you can't agree to it. So how does that square? How can you invite an error by agreeing to an illegal sentence?
Are you talking about the Apprendi line of cases where there's an agreed upon departure without a jury finding those facts?
I think, well, I don't have the case,
Okay.
but I know that we have said that you cannot stipulate to an illegal sentence. You cannot agree to an illegal sentence.
Okay.
Would you agree with that?
I would agree with that, but I would think the district court should have some discretion because a district court may correct a sentence. When you have a 68-month sentence and you're within the range of the next level anyway, and the defendant is begging the court to proceed, that we're not going to challenge this. We're so cooperative, Judge, that why shouldn't a district court be able to say, you can challenge this the next time you get charged with a crime? That's fair game. But for this case, you told me not to consider that. It just seems like something of fairness, and the defendant shouldn't be like an Eddie Haskell and be all nice at sentencing. And then when things go south on them, they can, oh, hey, King's X, motion to correct sentence, Judge. I think there still should be some discretion for district court judges to say no, invited error can apply in those cases, or not. The court here considered it anyway, as did the district court. So they really didn't consider invited error. They ruled on the merits. But I think the Court of Appeals followed well-settled law. They looked at the facts of what happened in Oklahoma. That is a procedural finding of guilt in Oklahoma, and it was properly included in his criminal history. Whether or not he objected or invited error, that was a conviction that should count, and I would ask that this court affirm the Court of Appeals.
Any more questions? Thank you, counsel.
Thank you.
Could you distinguish Macias for us from your client's situation?
Well, Macias was a finding of guilt in Texas, and let me check my notes because there's so many that they run together. And I think part of where Macias went wrong is that they didn't focus on whether or not it met the definition of a conviction. They started talking about if you do the crime, you do the time. That's what the legislative intended. But I think under the rules of statutory construction, they kind of jumped a couple steps, going straight to legislative history when we've got plain language of the statute here. Plain language of the statute gives us a definition. And if it's ambiguous, I think it breaks in favor of the defendant. But I think the distinction in Macias was that, again, they focused on whether or not we're comparing a deferred judgment to a diversion, and didn't really apply the Kansas definition of a conviction, which leads to the point that I think that we do. We're confined by the plain language of the statute here. And where Macias got off track, I asked the court not to follow that and to just look at the plain language. As far as a couple factual things, the defendant's Oklahoma records do have a pre-printed form. It's the advisement of waiver of rights, and then it's a fill-in-the-blank form where the court can mark go to prison, go to suspended imposition of sentence, or deferred judgment. So the defendant in his pro se motion also attached a letter, and that's at volume 1, page 83 is where his pro se motion starts, and I think it's about 5 or 6 pages in that the letter from the clerk of Oklahoma says, we don't have a judgment of guilt, we don't have, it's not there. So I don't think that a pre-printed stock form, which is used even in cases where a sentence of imprisonment is imposed and the case is not dismissed under their deferred judgment, statute should control over what ultimately happened, and what the Oklahoma statute says happens. You don't enter a judgment of guilt. So there's that factual information in the record. As far as whether or not my client could get consecutive sentences if we are reversed and remanded for sentencing, I think there's a constitutional issue there. Off the top of my head, I think North Carolina v. Pierce says that you can't ding someone for exercising their appellate rights or their post-conviction rights and give them more of a sentence just because they prevailed on appeal. But aside from that, I think this really is just a plain old statutory interpretation case. And when we start trying to compare dispositions across jurisdictions, we're missing the way it's supposed to go, which is just by the definitional aspects.
Even Judge Atchison concurred rather than dissented because he felt like Pollard was controlling.
I see Pollard, but again, that's Missouri. They enter a judgment of guilt, but they suspend imposition of sentence. There's still that judgment of guilt portion from Missouri that I think really drives what a conviction is for Kansas sentencing purposes. So I think we're distinguishable from Pollard because this isn't a Missouri case. We've got a different dispositional animal out of Oklahoma here than a Missouri SIS.
And again, the distinction between Missouri and Kansas is what?
I believe that on SIS that they do enter the judgment of guilt, but they suspend imposition of sentence. And under Missouri law, they don't count it as a conviction until you're sentenced, and so that's the benefit over Missouri. Although I'd ask the court to double check, I'm not 1,000% certain about that. That's what I believe it is. And if there's no other questions, I'd cede the rest of my time.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. We now